Let's talk about Form I-130, Petition for Alien Relative, and everything you need to know about it. Hello and welcome. Form I-130 is basically the way U.S. citizens or green card holders, lawful permanent residents, tell the government, hey, this person is my family and I want to bring them here legally. It doesn't give your relative a green card right away. It just proves the family connection so they can get in line for a visa. Now, who can actually file? If you're a U.S. citizen, you can file for your spouse, kids, no matter if they're young, grown, single, or married, your parents if you're over 21, and even your brothers and sisters, also if you're over 21. If you're a green card holder, the list is shorter. You can file for your spouse, your unmarried kids under 21, and your unmarried adult children over 21. But here's the catch. Green card holders can't petition for married kids. If your son or daughter gets married before they immigrate, the petition is basically dead. There are also some side rules. If you're filing for a spouse, there's an extra form, I-130A, they need to fill out. Some relatives don't need their own petitions, like if you're filing for your sibling, their spouse and under 21 kids might automatically be covered as derivative beneficiaries. Same goes for certain cases with green card holders. But not everyone can use I-130. For example, you can't file for an adopted child if the adoption happened after age 16, or if you never really lived with or had legal custody of the child for at least 2 years. A natural parent if you got your own green card or citizenship through adoption. A step relationship if the marriage that created it happened after the child turned 18. Some spouses, like if the marriage was only on paper, no real ceremony together or no real relationship, or if you married while your spouse was in the middle of deportation proceedings. Unless, of course, you can prove your marriage is 100% real and not for immigration purposes. And just to be clear, you can't file for grandparents, cousins, aunts, uncles, or in-laws. When it comes to actually filing, there are a few rules. USCIS only accepts forms with real handwritten signatures. No stamps or typed names. Photocopies of signed pages are fine, though. You can file the form online. You have to pay the filing fee. You need to send in evidence, things like birth certificates, marriage certificates, passports, or green cards, depending on the relationship you're proving. If documents aren't in English, you need a translation. Now, here's an important part. Just because the petition gets approved doesn't mean your family member can hop on a plane tomorrow. If they're your spouse, parents, or unmarried kids under 21 and you're a U.S. citizen, visas are immediately available. But for other categories, like siblings, married kids, or cases where the petitioner is a green card holder, there are limits each year. That means your relative has to wait until a visa number becomes available, and those waits can be years long. To file, you also need proof of your own status. U.S. citizens can use things like a birth certificate, naturalization certificate, passport, or consular report of birth abroad. Green card holders need a copy of their green card, or at least passport pages showing permanent residency. Proving the family relationship is a big part. For a spouse, you need the marriage certificate, proof that any old marriages ended, photos, and extra documents that show it's a real marriage, like joint bank accounts, leases, kids together, or affidavits from people who know your relationship is legit. For a child, it depends if you're the mom, dad, step-parent, or adoptive parent. Different documents apply, like birth certificates, marriage certificates, or adoption decrees. For siblings, you show both of your birth certificates to prove a shared parent. For parents, you submit your birth certificate and sometimes their marriage certificate. There's also a warning. If you've been married for less than 2 years by the time your spouse gets their green card, they'll only get a conditional green card. That lasts for 2 years, and then you both have to file another form, I-751, to remove the conditions, proving your marriage is still real. If you forget to do that, your spouse could lose their green card. And finally, if names don't match the documents, you'll need proof of legal name changes. If official records don't exist, you can use secondary evidence like school or church records, or even sworn statements from people who knew the facts. And in tough parent-child cases, USCIS might even accept DNA test results from an accredited lab. So basically, Form I-130 is the first big step in helping your close family immigrate, but it's not the finish line. Thanks for watching.